Copyright Amendment Service Providers Bill 2017. Motion on second reading.
I call the Honourable Minister.
I present the explanatory memorandum to this bill, and I move that this bill be now read a second time. Mr Deputy Speaker, there are significant opportunities in the digital environment for improving the way we provide educational services, provide services to people with a disability and promote cultural and historical experiences in Australia. Many of these opportunities, however, may put Australia's educational and cultural institutions and organisations assisting people with a disability at a high risk of copyright infringement. There is a balance to be struck between encouraging the development of new and innovative services for the benefit of all Australians and ensuring that Australian creators can retain control and derive value from their copyright-protected material. Ensuring respect for the creative efforts and economic rights of creators is an ongoing challenge for all participants in the digital environment. Extension of the Safe Harbour scheme to service providers in these sectors will provide greater certainty to educational and cultural institutions and to those organisations assisting people with a disability about their responsibilities in engaging in the online space. The current Safe Harbour scheme in the Copyright Act 1968 was introduced following the commencement of the Australia-United States Free Trade Agreement in 2005. The scheme in the Australia-United States Free Trade Agreement was intended to provide an alternative to court proceedings for copyright owners where their infringing material is hosted, cached or linked to by a service provider, or where a provider's network services are used to infringe copyright. It sets out conditions with which a service provider must comply, including, in some situations, taking down infringing material or removing links to infringing material when they have been notified of a suspected infringement by a copyright owner. When the scheme was originally implemented in Australia, it was restricted only to carriage service providers or providers of telecommunications services, such as internet service providers, as they are more commonly known. This cautious approach was taken because the internet was still in its infancy. This bill, through the extension of the existing Safe Harbour scheme, will ensure that a greater range of service providers can work with copyright owners to effectively protect copyright material without recourse to litigation. The extended scheme enabled by this bill will apply the Safe Harbour provision to educational institutions such as universities and schools, as well as libraries, archives, museums and organisations assisting people with a disability. Where these additional service providers comply with the requirements of the Safe Harbour scheme, including the operation of a notice and takedown system, their liability for monetary remedies will be limited. The education, cultural and disability sectors generally take a very risk-averse approach to protecting and managing the copyright of others. Many of the institutions and organisations who, under this bill, will be covered by the Safe Harbour scheme already comply with the requirements of the scheme and actively work with copyright owners to remove or disable access to infringing material residing on their systems or networks, or to take action against repeat infringers. In doing so, they dedicate a significant amount of resources on their processes, yet they still remain potentially liable for the infringement of their users, which is beyond their active control. This bill will reduce the potential exposure of these sectors to legal liability for authorising copyright infringement when third parties use their networks or services in a way that breaches copyright. This amendment will provide certainty to a group of institutions and organisations which provide services that are in the public interest and will support them in being more innovative in the online environment. This will therefore encourage these institutions and organisations to create and deliver enhanced online services for all Australians. Copyright owners will benefit from the extended scheme, as it will provide them with a consistent mechanism for working with those organisations covered by the bill to address copyright infringement on a broader scale, rather than having to pursue each and every individual who infringes copyright online. Last year, the government introduced and passed the Copyright Amendment, Disability Access and Other Measures Act 2017, which was the result of a collaborative effort between rights holders, the education and cultural sector and the disability sector. The passage of the Disability Access Act was an important step in simplifying and modernising the Copyright Act 1968 in response to specific challenges and concerns identified by rights holders and those sectors of the community. This bill now builds upon the effective working relationship that already exists between these sectors and copyright owners as a result of the Disability Access Act. Users of these institutions and organisations' services will also have additional protection under the Safe Harbour scheme. The changes will give users a clear process for ensuring that where their material is removed from the institutions or organisations, systems or networks, in line with a notice under the Safe Harbour scheme, it can be reinstated when the user can demonstrate that the material is not infringing. This will ensure, for example, that students and researchers can protect their legitimate use of copyright material in online forums. The government has made the decision to make this incremental expansion of the Safe Harbour scheme so that it can continue to consult on how best to reform the scheme to apply to other online service providers in the future. In Australia, the expansion of the Safe Harbour provisions has been reviewed in 6 separate government reviews over a period of more than 10 years. Each of these reviews called for submissions from the public. The Productivity Commission's 2016 review of Australia's intellectual property arrangements was the most recent of these reviews, and it recommended that the scheme be extended to all online service providers. The government is, however, aware that a blanket extension of Safe Harbour remains a highly contested reform. This is why we chose to undertake further consultation last year. The consultation demonstrated the full spectrum of views, from complete support to strident opposition. Both sides are worthy of a full examination. The government has appreciated the open and frank dialogue that we have had with representatives from both sides. On the one hand, we have heard that extending Safe Harbour would encourage piracy, contribute to the gap in revenue between subscription and ad-based content services, and remove the ability for rights holders to seek licence revenue from online services. Of particular concern have been scenarios in which service providers derive profit from the infringing activities of their users. There are also strong concerns that the current conditions in the Safe Harbour scheme are no longer effective in addressing infringement, and that they need to be reconsidered to ensure they promote a collaborative and supportive online environment. On the other hand, we hear that Australia has legal uncertainty about the extent to which service providers can be liable for the actions of their users, which has a chilling effect on innovation. Service providers, who in many cases perform the same role as a carriage service provider, have pointed out that they are the ones that have no protection, and that this makes Australia uncompetitive compared with other countries who have a Safe Harbour scheme. Internet users and service providers alike have argued that Safe Harbour provides a simple, non-court-based option to address infringement on the internet which should be a good thing for the creative sector. The worst outcome would be for the government to inadvertently impact on rights holders' ability to realise returns on their creative and financial investments. Australia has thriving creative industries whose work contributes enormously to our economy and our cultural life. The government is trying to achieve an environment that encourages innovation, but does not want to do that at the expense of a vibrant cultural and arts sector and the thousands of Australians it employs. At the same time, the government recognises that there are many institutions and organisations that operate in the public interest of all Australians, and there are actors on the internet who are trying to build a robust and innovative Australian digital economy. So far, opposing parties have been unable to meet in the middle of this protracted debate. So, this bill starts the process of safe harbour reform by responding to an area where there is broad consensus, extending the scheme to a group of institutions and organisations that all agree are responsible players in the copyright space. The current Australian Safe Harbour scheme, which this bill will extend, is governed by procedural provisions in the Copyright Regulations 1969. These regulations provide the additional details about exactly how the Safe Harbour scheme works, including how the industry codes must be developed, how notifications and notices should be issued and received, and the procedures for notice and takedown of infringing material. As part of the Department of Communications and the Arts review of the Sunsetting Copyright Regulations 1969, last year stakeholders had an opportunity to indicate how these provisions might be updated. The government remade these regulations in largely the same form as their sunsetting version, save for some further enhancements to give effect to provisions contained in the Copyright Amendment, Disability Access and Other Measures Act 2017. However, the passage of this bill will require some further updates to the regulations. Therefore, the government recently released an exposure draft of amending regulations to facilitate the extension of the Safe Harbour scheme for consultation prior to passage of this bill. The government will focus on ensuring that the mechanics of Australia's Safe Harbour scheme, contained within the regulations, operates effectively in Australia's digital environment for copyright owners and the broader range of service providers defined in this bill. The government will continue to work with stakeholders, seeking to find a way to further extend the Safe Harbour scheme in a way that allows Australian businesses to harness the significant opportunities of the growing digital economy, while ensuring respect for the creative efforts and economic rights of creators. The government is confident that through this staged approach it can find a way to provide a practical and responsive Safe Harbour framework that operates effectively in the Australian environment.
I thank the Minister. The question is that this bill be now read a second time, and I give the call to the honourable member for Isaacs.
Thank you very much, Deputy Chair. Labor supports this bill, the purpose of which is to expand the operation of the legal Safe Harbour scheme set out in the Copyright Act 1968 to a broader range of service providers. Labor has long advocated for this change, the change that is brought about by this bill, and we have worked with the government to bring this bill forward. The existing Safe Harbour scheme established by the Copyright Act protects carriage service providers, in particular internet service providers such as Telstra and Optus, from the civil liability that they would otherwise be exposed to for hosting or communicating material that infringes copyright. To be able to rely on this legislated safe harbour created by the Copyright Act, the carriage service provider needs to demonstrate that they operate a scheme for removing copyright infringing material if they are notified of such material by a rights holder. Such processes are, of course, popularly known as takedown processes. This legislation will extend the legislated safe harbour scheme beyond carriage service providers to include, first, educational institutions through their administering bodies, including universities, schools, technical colleges, training bodies and preschools. The bill also extends the safe harbour scheme to libraries that either make their collection available to the public or are parliamentary libraries through their administering bodies, to archives through their administering bodies, including the National Archive of Australia and specified state archives, galleries and museums, to key cultural institutions through their administering bodies, including specific archives and libraries that are not open to the public, and finally to organisations assisting persons with a disability. The extension of the Safe Harbour scheme pursuant to this bill is generally supported by rights holders and their peak groups because it provides a social good without undermining the commercial interests of content creators or their capacity to negotiate effectively with commercial enterprises for the distribution of their copyright materials. Labor has consulted widely on this bill, as indeed has the government. We support the bill because it will provide greater legal protections for our schools, for our universities, for our libraries and cultural institutions to operate efficiently in the digital age. At the same time, this bill balances the interests of rights holders with those of the important educational and cultural institutions that will benefit from the extended protections provided under the expanded Safe Harbour scheme. This is in part because the entities protected by the expanded Safe Harbour scheme established by this bill do not benefit financially from the use of content on their networks, and so these reforms cannot be said in any way to distort the commercial market. Labor supports this bill as making balanced and reasonable reform to copyright law, and we will continue our consultations with stakeholders on whether further changes to the legislated Safe Harbour scheme under the Copyright Act may be desirable.
I thank the honourable member. The question is that this bill be now read a second time, and courageously, as he steps into the breach, I give the call to the honourable member for Scullin.
Thank you, Deputy Speaker. I'm pleased to join the Shadow Attorney-General, the member for Isaacs, in making a brief contribution in support of this bill. As the Shadow Attorney-General has said, the provisions which are constituted in this bill are by and large matters for which the Australian Labor Party has long advocated for, and we welcome their introduction while recognising there is of course some way to go in order to fulfil some of the wider policy challenges posed in the area of copyright law. This is a dynamic area of the economy, yet it would appear this is an area where our lawmaking processes have not kept pace with needs. And very briefly, Deputy Speaker, in my own portfolio responsibilities in schools and in universities, these are areas where the issue of the expansion of Safe Harbour is particularly important. So in that regard, I note the Shadow Attorney-General's comments about the social good that really lies at the heart of getting this balance right between rights holders and societal interests. And on the basis of that, and in recognition of very wide consultation undertaken by the opposition, acknowledging also the work of the government, I commend the bill to the House.
I thank the honourable member. The question is that this bill be now read a second time. I give the call to the honourable member for Griffith.
Thanks, Deputy Speaker. This is a very important bill because it is a fact that for many, many years there's been a lot of contest in relation to copyright law in Australia, and that